In this session, we're going to continue our examination of torts. We're going to discuss negligence and strict liability. Negligence, as you recall, we distinguish negligence and intentional torts in the intentional torts slideshow. But just as a reminder, the main difference is that negligence does not require intent. And the intentional tort requires that you have the intent, not necessarily to have the exact harm or the exact consequence that happens, but you have to have had some intent to cause the act, knowing that there could be consequences for that act. Negligence, on the other hand, you're not looking for that intent. In fact, a lot of times the intent is missing. Rather, what you're looking at is the reasonableness of the defendant's conduct. To give negligence a definition, negligence is the defendant's failure to act as a reasonably prudent person would under similar circumstances. And it's important to note that negligence can result from either an act that's taken or a failure to act. So an omission of action could be a basis to establish negligence. Thus, in negligence, the defendant does not have to intend or know that his action could cause an harm. Rather, we're looking at whether what the defendant did failed to be along the standard of what a reasonably prudent person would have done in the. So a plaintiff must prove 4 elements in order to recover on a negligence basis. These 4 elements are 1, duty, 2, breach of that duty, 3, causation, and 4, damages. So when we say duty, we'll examine all these in more depth in a moment, but just briefly, a duty is the defendant must owe the plaintiff a duty. That means that the the defendant must conform to some standard of care. There's an expectation of how the defendant should act towards the plaintiff. Then the breach is where the defendant's conduct fell below that standard of care, where the defendant did not act in accordance with the way they were supposed to. Damages, that's the easy one of when you have an injury to either the person or their property. And the causation element links the damages with the breach of the duty. And so you've got to have the causal connection that ties the wrongful conduct to the actual injury or loss that the plaintiff suffers. So duty, let's initially look at element 1, duty. A duty arises when there's a relationship between the defendant and the plaintiff that requires the defendant to act in a certain manner towards the plaintiff. So there's an expectation of how the defendant should act towards the plaintiff. The easiest example in the business context is we can talk about a storefront, a retail operation, and guests that come to shop there. Obviously, you have a duty as a business owner to provide a safe premises to people who come on your property. That would be the duty to provide a safe property, a safe environment for them to be in. So if you have a store, you've got to protect against a hole being in the floor or in the parking lot to where a plaintiff could be walking, a customer could be walking and they could not see it, they could hit it and fall and break an arm, drop a child, whatever. There could be harm that could arise from that hole. So you would have a duty to make sure that your premises is safe, whether you repair that hole or you protect through warning them of it. You would have to undertake some action in order to protect the customer to your store. So in that scenario, you would have a duty to do that. So if there's a duty, then you're required to act reasonably under the circumstances and avoid that harm to the plaintiff. So the action here in the scenario we just gave as the store owner is to fix the hole in the floor. And by fixing the hole in the floor, you're avoiding the harm that could happen to the plaintiff, to the customer, because of that hole. The standard of care that we talk about is an objective one. And by saying it's an objective standard, we mean that you look at what a reasonable person of ordinary prudence would do under the circumstances. You don't put yourself in the position of that defendant. You don't put yourself in the shoes of this one business or this one person. Rather, you put yourself in the shoes of what the ordinary and reasonable person would have done under the circumstances. If you want to think of it in generic terms, it's what would the majority do in this situation? Faced with these circumstances, what would a reasonable person, what would have been the normal reaction? So that's where you're looking at an objective standard rather than the subjective nature of this specific defendant. So whether a defendant owes a duty to the plaintiff, that's a question of law for the court to decide. So that's not necessarily something that the parties decide or the jury will decide. Rather, it's a determination made by the court, because if there is no duty, then there is no negligence claim. So it's a question of law that the court decides. So we have an example here, and that ties in with the example that we just talked about, where businesses have a duty to warn or protect against foreseeable risks of harm. Similar example is where drivers, if you're driving a vehicle on the road, you have a duty to exercise reasonable care when you're operating that vehicle to avoid injury to either a pedestrian or another driver. So the book goes through several different general duties that arise, and we'll look at a few of those. The duty to rescue. The general rule is that there is no duty to rescue. But there is a duty to rescue if you created the peril. So if you were the one who's responsible for putting the person in need of a rescue, you would have a duty to then act, a duty to rescue that person. The book gives a good example of where if you have somebody in a boat and you're responsible for knocking the person out of the boat, you would have a duty to go back and rescue the person once they've been thrown overboard. But if you're sitting on a hill and you observe somebody in the water struggling, you don't have a duty to rescue them under the general rule. But if you undertake a rescue, if you are sitting on that hill and you see the person drowning, if you undertake that rescue, then you have a duty to act with reasonable care and complete the rescue. So you can't, I think the example the book gives is the same boat example. If you're sitting on the hill and you see someone in the water struggling and you go get in a boat and go out to them and you see them and you decide, oh, well, that's somebody who I don't like, you can't turn around and leave because you've undertaken the duty to rescue that person. You would have an obligation at that point to act with reasonable care, and a reasonable person would save the person that's struggling in the water. And so you'd have a duty to complete that rescue. So when the duty to rescue can arise, you may have a duty to rescue. This would be an exception to the general rule if you have a special relationship. And some of those relationships are that of a parent and child, husband, wife, parent, child, employer, employee, innkeeper, guest, and teacher, student. Another area that the book looks at in terms of general duties is the landlord's duty to his tenant. So in the landlord context, this is where you have a person who rents an apartment. The renter, the person that moves in, is the tenant. The person that owns the property that's letting them live there is the landlord. So in that scenario, the landlord generally has a duty to provide protective measures, security that will protect against foreseeable criminal acts committed by a third party. So example is if you have a propensity for robberies in your area, then you have a duty to perhaps provide security and protect against those robberies. So how would you do that? You may put in lighting, better lighting. You may put in an electric gate that keeps people out that aren't tenants there or invited guests. You may hire a security guard that is either lives in the property or patrols the property at night. All those things would be options that could be taken to protect against the foreseeable criminal act of robbery. So there's a few factors that you'll consider when you try to determine if the criminal act is foreseeable. One is you look at the location of the property. Is the property in a high crime area? If it's in a high crime area, then it's more likely that criminal activity is foreseeable. If you're in an area that's generally safe, of course, then there's a less likelihood that the criminal activity will occur and it's less foreseeable. You also look at the history. Has there been any prior incidences of criminal activity? If there has been prior incidences involving criminal activity, then the landlord is kind of put on notice, and if there's a prior history, then it's more likely that it's foreseeable that criminal activity will occur again in the future. And you also got to consider knowledge. If the criminal activity is happening but it's not known by the landlord, then that weighs in favor of there being no duty. Because if the landlord doesn't know about the criminal activity, how would they know that they should that they have a reasonable basis or expectation to protect against that third-party criminal activity? So another area of duties that the textbook covers or examines is that of landowners and occupiers of land. So by landowners, we mean the person or the entity that owns the land. By an occupier of land, it could be someone that leases the land and uses it. It could be like a tenant. And if you go to a strip mall, someone's going to be the landowner of that area, but then you may have 12 businesses in that strip mall. Well, those occupiers would be responsible for their store and the safety of that store. So when we're talking about the duties of the landowners and occupiers, we're talking about what's commonly referred to as premises liability. And so the landowners and occupiers of the land, they have a duty to keep their property reasonably safe from foreseeable risks of harm. So you go back to the example that we talked about initially when we looked at the first slide on duty, is the business owner. There's a hole in the floor. There's a spill of water on the floor, something like that that's going to create a risk of harm. It's foreseeable that somebody could trip on a hole in the floor or that somebody could slip and fall on water on the floor. In those instances, the landowner and occupier has a duty to protect and warn against those foreseeable risks of harm. So, and when I say they have the duty to protect or warn, by protect, I mean they have a duty to repair it, to remove the harm. So if it is a hole in the floor, they've got a duty to cover the hole and take it to where it's again a flat surface. If it's the water on the floor, they have a duty to sweep, mop the area, dry it so that the floor is no longer slippery. But if it's a risk that they do not repair, then they have a duty to perhaps warn about it. The common example of warning is when you go to a parking lot and you may have a step up from the parking lot to the curb to then enter the store. Well, sometimes those curbs will be painted yellow, and that's where they're protecting against a foreseeable risk, because it's foreseeable that a person could come walking, not be paying attention, and not realize the change in elevation between the parking lot and the sidewalk, hit it and fall. So they've put that yellow line there to help draw attention and warn that, hey, there's an elevation change here. You need to step up onto the sidewalk. So implicit in these duties to protect and to warn is that you in turn have a duty to inspect your property. If you're not inspecting your property, then you can't protect or warn against a foreseeable risk. You need to be inspecting your property so that you can understand what those foreseeable risks of harm are, that you can find the holes or the uneven pavement or the water on the floor. And you can also gain knowledge of those things through one, incidences that happen. So if someone falls on a hole, then you are clearly on notice that that hole exists. By contrast, or not necessarily contrast, but similarly, the person could see the hole, not fall in it, and they could come and report the hole to you. In all of those instances, you now have knowledge of it and you have a duty to protect against that risk of harm. So latent conditions, those are conditions that aren't known about and can't be known about. There's going to be no duty there. So you have no duty to protect or warn against unreasonable risks of harm. So an example is if there is, say, the roof has gone bad and you can't tell it because it's underneath, the roof is leaking and the wood, the decking is becoming saturated with water, and you can't see that, but it may cause a roof to collapse. And if you didn't, it's not reasonable that you're going to get up on the, and it's not foreseeable that you're going to get up on the roof and learn of that because it's underneath the shingles. And so in that instance, that could be one type of a latent defect that could occur. If that, in that case, you would more than likely not have any duty in that scenario. So the book, when they talk about premises liability, they talk about the different classes of persons that may be on your property. So the first one they talk about is the trespasser. The general rule is that there's no duty that's owed to a trespasser. An exception to that is that if the trespassers are routinely there and it's known, then the possessor or landowner has a duty to exercise reasonable care to protect or warn in that area. So if you have land and you know that kids are sneaking onto it, or teenagers are sneaking onto it, and they're playing hide and go seek because it's a good area in the woods, then you would have a duty to perhaps protect or warn against unforeseeable risks of harm in the area that they're at. The duty of care is heightened when the trespassers are children. And so that is because of the attractive nuisance doctrine. And the thought is that there is some condition that's on the property that you've created that is attractive to the kids. It's making them want to come on there, whether it may be a pond or if you've got a basketball court, something like that may be attracting them on. And so if they come on the land and are attracted on there, then you have a heightened duty and you're going to have liability for physical injuries that those children suffer as trespassers because of them being enticed onto the property. Now, the other two classes are licensees and invitees. So historically, different duties have been assigned based on whether the person is an invitee or a licensee. Licensees refer to people who are entering the land, usually with either express or implied consent. And these were mainly more like social gathering. It's where you had a home, you invited Doug and Judy and Pam and Bill to come over for a cookout. In that instance, they're licensees because they're entering the property at your invitation, your request for them to come on, and they've got consent, your express consent to be there. If they come on and they are injured on your property, then you would owe a duty to them to protect or warn against foreseeable risks of harm. The invitee is a person who comes on the property for a business purpose. So if it's a business and if you're a grocery store and you sell groceries, someone who comes in to buy groceries is an invitee. Um, these distinctions have essentially been abrogated or abolished in the majority of jurisdictions. In Tennessee, there's no distinguishing between an invitee or a licensee. Under Tennessee law, like the majority of jurisdictions, if you're invited on the premises, then you have a duty as the landowner or possessor to exercise reasonable care to protect or warn against foreseeable risks of harm. So it goes back to just like we were talking about, whether you're inviting people over for a social gathering at your home or you're a business that's open to the public and have customers coming in, either way, you're going to owe a duty to exercise reasonable care to protect or warn against foreseeable risks of harm. So the second element, let's start looking at the breach. So we've talked about what is the duty and how is it defined, and it's where you have an obligation to conform to some expectations of how a reasonable person would react under those circumstances. So the breach is very easy in that that's where you failed to comply with what's expected of you. So once you define what the duty is, what the expected standard of care is, then you have to analyze whether the defendant actually breached that duty. In other words, did the defendant actually deviate from the standard of care? Is what they did considered a violation of what was expected of them? Again, this goes back to the objective standard of the standard of care is what the standard of a reasonably prudent person under similar circumstances would have done. And so if the defendant's actions are different than that or they deviate from that, then there may be a breach of the duty. For specialty areas, and we'll talk about this in just a little bit later, we'll talk about professional malpractice. For specialty areas, the defendant's going to be held to how a reasonable person in that industry would act. So a lawyer is going to be held to how a reasonable lawyer would act, not how just a reasonable common person would act. Negligence per se, this is a doctrine that comes in and it's a form of ordinary negligence. It just helps you establish what the standard of care is and helps you know whether it was violated. And so sometimes in this doctrine, you can have a statute or a regulation that may define what the expected conduct by the defendant is. The statute and regulations, if there's a statute that's on it, it's not automatic that it's going to be a statute or a regulation that defines how the defendant should act or what their conduct should have looked like. In order for a statute to do that, or regulation, the statute has to be specific in defining what standard the defendant is expected to follow. So if it's just the statute talks in general terms, that's not going to be enough. Also, if the statute talks in terms of how an ordinary and reasonable person would act, then that's really not defining any standard because that's what you would expect under the ordinary duty analysis. So a negligence per se has to be where the statute clearly defines some conduct. As an example, if you have a statute that says that in a certain situation the defendant must do X, Y, and Z, that may define the standard of care that the defendant has to exercise. So in a banking situation, there's a statute in Tennessee that says a bank must, when it's making a payment, and we've talked about this example before, but when a bank is making a payment in a construction loan context, the bank has to make the check payable to both the borrower and the builder. And in that scenario, there's an argument that that statute defines the bank's conduct. It defines the standard of care that the bank has to comply with. And if the bank fails to make the check payable to both the builder and the borrower, then they have arguably violated the standard of care. So that would be a statute that may be specific enough to define the standard of care. But in Tennessee, there are a number of statutes that define the rules of the road, and they define expectations of how a driver should act. And some of those are in the very general terms of how you would expect a reasonably prudent person to act while driving a car. Those statutes do not, likely they do not define a specific enough standard of care such that they would be able to establish negligence per se. So if you have a statute that says that a driver must use due care in operating the car or in switching lanes, that expectation is there under the objective reasonable person standard that we've talked about. So that statute is not going to be specific enough in defining the conduct that's expected of the defendant. So those statutes on the rules of the road are most likely not sufficient to establish a standard through the process of negligence per se. So you would go back to the standard of a reasonable person. How would the reasonable person act in that under those circumstances, as opposed to the statute says that the defendant must have acted this way when operating his car. So causation, determining whether there's a duty and determining causation. Those are usually the two hardest analysis or two hardest elements of a negligence claim. So causation, so once that you have a breach of the duty or an alleged breach of the duty, because that's a decision that's made by the fact finder, just like causation is, then the plaintiff must establish that the alleged breach is what caused the plaintiff's injuries. So you've got to have that link between what the breach was and what the injuries are. You can't just have, well, somebody breached conduct, they had conduct that breached the standard of care, but it didn't really cause any injuries, but I do have other injuries for another reason. So the book gives it a good example in that scenario of where you have a person who put the trash out and the lady was running and got hurt and fell, but it was because she tripped her ankle rather than hitting the trash can. And so her injuries were caused by her rolling her ankle, not by anything with the trash can and the conduct of the defendant. So there you would lack that causal connection, because whether the garbage can was there or not, she would have still suffered her injuries. So in causation, there are two types of causation. You've got to have actual cause and you've got to have proximate cause. And courts will look at these, and you may meet one, but you may not have proximate cause. And if you don't have proximate cause, you're not going to have a successful claim. You've got to have both actual cause and proximate cause. Only having one is not enough. It's also important to note that proximate cause you may see in the book or in somewhere else where they refer to something as legal cause. Legal cause is another name used to refer to proximate cause. Proximate cause and legal cause mean the same thing. So actual cause, this is what's known as but-for causation. So the idea is that the plaintiff has to prove that but for the defendant's conduct falling below the standard of care, so but for the defendant's breach, the plaintiff would not have suffered the injury. So you've got to show that because of their conduct, I suffered the injury. So if the plaintiff would have suffered the injury even in the absence of the defendant's conduct, then there's no actual cause. So the example that we just talked about is goes right to the actual cause, where you have a lack of but-for causation, because in the absence of that defendant putting the trash can there, the injury was still going to happen because she rolled her ankle and had nothing to do with the placement of the trash can. Actual cause can become very interesting when you have multiple defendants. When you have multiple defendants, it's hard to say but for, because it may have been conduct by several people that establishes that causation. And so since you can't necessarily get to but for, then you substitute in, where the conduct by the defendant has to be a, quote, substantial factor, close quote, in causing the injury. So it's not in the but-for analysis, it's the sole reasoning. In the multiple defendant analysis, it's just got to be a substantial factor. So it has to substantially contributed to causing the plaintiff's injury. With multiple defendants, it's also possible that it can be difficult to establish who the cause of the injury was. The book gives the example of where you have two hunters and they both shot at a bird, and if it hits somebody, then you don't know whose shot was fired is the one that caused the injury. In that scenario, the court will put the burden on the defendants and say, well, you establish who it was. And if you can't establish who the person was that caused the injury, then the defendants are both going to be held liable. Proximate cause. This is where the plaintiff has to show that the defendant actually had a duty to protect the plaintiff from the specific conduct that injured him or her. So this is where the law tries to place some limits on the defendant's liability, place some sort of a limit on how far out, how foreseeable the conduct has to be. So the limit is that you only are liable for protecting the plaintiff from harm that was reasonably foreseeable. So it goes right back to what we've talked about. Everything is about this reasonable foreseeability. And so it places some sort of constraint or limit on the defendant's liability. The defendant's not liable for every possible harm that could have occurred. This is very well demonstrated through the Palsgraf case. The Palsgraf case is a very important case in legal theory on proximate cause, and it's the case that's studied probably every tort class across the country in law school. And proximate cause in that case was defined by the concept of a zone of danger. So that's what you can think of is that it places a circle around the possible liability and says if it's in this circle, then it's something that the defendant can be liable for, because in the circle is conduct that's reasonably foreseeable. But anything that happens outside of that circle is not reasonably foreseeable. It's unforeseeable, and therefore it's not something that the defendant would be liable for. In other words, there would be no proximate cause for any of the conduct that is outside of the circle. The conduct inside that circle, that zone of danger, is conduct that the defendant could be liable for. There would be proximate cause for that conduct that's in the zone of danger in that circle. So the Palsgraf case is a great example. So in that case, you have the plaintiff who is standing. It's at a railroad station. It's out as someone is getting on a train. The plaintiff is standing over near the building, and there are some scales that are hanging on the wall or from the roof. I'm not sure, but there are some scales that are hanging near where the plaintiff is standing, and away from the plaintiff, not where she's at, but quite a ways from her, is a gentleman. I believe it's a gentleman, but someone is getting on the train as a passenger, and they have a wrapped box that has fireworks in it. As the person's getting on the train, that box is dropped and it hits the ground, causing the fireworks to go off. And as a result of the fireworks going off, the scales fell down and hit the plaintiff, and the plaintiff sues over it. The court came up with a zone of danger theory. They found that the likelihood of the scales falling and hitting her were outside the zone of danger in the Palsgraf case, and so they didn't see it as it was not foreseeable that a person would get on, have fireworks, the fireworks would go off and cause the scales to fall off and strike the plaintiff. They found that causal connection to get there was too remote. There was too much between it. So you lacked proximate cause in that scenario. So for there to be proximate cause, it's got to be an injury that's foreseeable, and that is in the terms of it's something that's within the zone of danger. It's specific conduct that was foreseeable such that the defendant had a duty to protect against that specific conduct. Res ipsa loquitur. This is similar to like negligence per se. It's a part of, it's not a separate doctrine, but it helps aid a plaintiff in proving his or her negligence claim. So res ipsa loquitur, it translates into the thing speaks for itself. So it's a doctrine that helps the plaintiff prove the breach of the duty and the causation element when breach and causation is unknown. So typically these scenarios, there's an accident that's happened, and the accident's a type that would not have occurred without someone having been negligent. And so when we say that they can't prove it, it's because there is no direct evidence of what happened. No one saw exactly what happened. So these claims require that the plaintiff prove three things. One, the plaintiff has to prove that the incident was a type that generally does not happen with negligence. It was caused by an instrumentality that was solely in the defendant's control. And three, the plaintiff did not contribute to the cause. So an example would be if you have the plaintiff is standing outside of a business, and from the second floor of the business, a say a small barrel that's holding, say, 5 gallons of a drink, rolls out the window and falls and strikes the plaintiff in the head. Well, the plaintiff didn't see what happened. The plaintiff and no one else may know what happened. And that's a scenario in which the plaintiff may rely upon the res ipsa loquitur doctrine to prove negligence against the defendant, the store. This is a type incident that doesn't happen without negligence by somebody. Barrels of a drink don't normally fall out of windows of businesses. So that's something that generally wouldn't happen without negligence. The thing that caused the negligence, the instrumentality, was solely in the defendant's control. That barrel on the second floor of a business is likely in the control of the defendant. And then it's obviously something that the plaintiff did not contribute to cause. The plaintiff didn't have a hand in causing the barrel to roll out of the window and strike him or her on the head. Most commonly, when you do have the res ipsa loquitur doctrine that applies, it usually allows there to be a presumption that's rebuttable of negligence. So if you establish that it applies, then generally negligence is presumed, subject to the defendant then rebutting that they were negligent. So the last element here is injury. Injury is pretty simple in that there must be some injury to either the person or the property. If there is no harm that's caused by the defendant's negligence, by their breach of their duty, then the plaintiff cannot recover. Without any damages, then there is no basis to prevail on a negligence claim. So we've had several of these cases that I've been involved in where maybe there was a technical breach, but there were no damages from from any technical breach. An example I can go back to is we've talked about the bank scenario where the statute obligates a bank in a construction loan to make the construction payments on a check that's payable to both the borrower and the builder. In that scenario, the case that I was involved in where that became an issue, there were no damages because the bank did not know of that statute, and the bank did not make the checks payable to both the builder and the borrower. The bank just made the check payable to the builder. In that scenario, they arguably violated that statute. violated their duty. But there was no damages that the defendant, that the plaintiff, the borrower suffered because her name wasn't on the check. And so since they couldn't establish any damages that was caused by the mere technical breach of the statute, their negligence per se claim failed. So, like anything, there are defenses to negligence. So, the biggest defenses is that the plaintiff was also negligent. Now, you've got doctrine of contributory negligence compared to, the book refers to it as comparative negligence, but it's commonly referred to as comparative fault. And contributory negligence is the older doctrine of the two, and the comparative fault is the more current doctrine that is um, pretty much adopted in probably every state in America. So contributory negligence, this is the old standard. And under the contributory negligence doctrine, if the plaintiff's negligent at all, if there was anything that the plaintiff did that contributed to the accident, even if it was very remote, very small, if they were negligent at all, then the plaintiff was barred from recovering anything. So if you use percentages, if the plaintiff was found to be 1% negligent and the defendant was 99% negligent, that 1% was enough to bar recovery. So this rule, of course, was found to be inequitable to plaintiffs and was replaced by the comparative fault doctrine. Comparative fault is the new standard, is the prevailing standard, and is probably the standard in every state in the United States. Under this theory, the plaintiff is allowed to recover the proportion of the defendant's fault. So if we go back to the example that we just did, where the plaintiff is 1% negligent, then the recovery is only offset by 1%. In other words, the plaintiff would be able to recover 99% of whatever the damages are. There are two types of comparative fault. There's pure comparative fault and ordinary comparative fault. I believe that the ordinary comparative fault is the majority standard by a pretty good bit in the United States, but it's what Tennessee has, is where the plaintiff's recovery is permitted only if the plaintiff's fault is less than the defendant's fault. So in most cases, the defendant has to be at least 51% liable. If it's 50-50, it's not enough in a lot of states. There are some that it would be enough, but the plaintiff, their contribution to the negligence or the accident, causing the accident, has to be 49% or less. If it's 49% or less under an ordinary comparative fault state, the plaintiff would be allowed to recover the proportion of the defendant's negligence. So if you have an ordinary comparative fault state and the jury decides that the actions of the defendant are 60% responsible for the accident and that the actions of the plaintiff are 40%, then the plaintiff would be entitled to 60% of the award. So if the jury said that it's 60% to the defendant and they awarded $100,000, then the plaintiff would be entitled to $60,000. So whatever the plaintiff's fault is works as an offset against any recovery. So it reduces the amount of damages that the plaintiff would ultimately receive. So even if it can't act as a complete bar, it can limit the liability that the defendant has. So even though it doesn't act as a complete bar, comparative fault still helps lessen the liability of what a defendant would owe the plaintiff. The other form, the pure comparative fault, in jurisdictions with this, the plaintiff's recovery is permitted irrespective of their negligence. So you don't have to have 49% or less negligence on the defendant, or excuse me, on the plaintiff. If the plaintiff is 80% negligent and the defendant's only 20% negligent, in a pure comparative fault state, the plaintiff is going to be entitled to recover that 20%. The ordinary comparative fault rules, that plaintiff would be barred from recovery because they're primarily responsible for the accident. Another defense is the assumption of risk doctrine. So this doctrine essentially acts as a bar on the plaintiff's recovery when the plaintiff knew the risk in advance and they consented to it. And so for this to apply, the plaintiff must have, one, known and understood the risk, yet they voluntarily chose to incur that risk. So this is similar to the consent defense that we talked about with an intentional tort. So the intentional tort was you're consenting in a sporting event to the touching that could cause harm. In this instance, it's similar. You're consenting to conduct that could cause that has a risk and could cause injury or harm to you. The example is Sky Zone. Sky Zone in Jackson. You may not have one where you live, but a Sky Zone is a trampoline park, I guess is the right word. But they have trampolines. You can go in, you can jump and dunk basketballs. You can jump into a foam pit, but there's an element of risk involved in jumping in those places. And so you know the risk, you've confronted that risk, and you've agreed to take that risk by going in and jumping. And so if you get hurt at Sky Zone, you've assumed that risk. Now, if you get hurt for some other reason than just jumping on the trampoline and landing on your ankle or your knee wrong and tearing an ACL or twisting an ankle badly, if there was some other risk of harm that was posed there and you didn't know it, you would not have assumed that risk, but you have assumed the risk of an injury that could occur from jumping on the trampolines. So briefly, I think it's important to compare and contrast negligence with breach of contract cases. So we've talked about the breach of contract. You've got to have the valid contract, somebody's got to breach that contract, and you've got to have damages from it. So in some states, and Tennessee is one of these states, the states will preclude a plaintiff from asserting a breach of contract claim as a negligence claim. That means you can't recast a breach of contract claim as a negligence claim. So the argument is that the defendant was negligent in performing his or her obligations under the contract. So if you're required under the contract to build something and they argue that you built it improperly, there's a question of whether you have a breach of contract claim or a negligence claim. And if you're simply trying to say that you breached the contract in performance because you perform poorly, negligently, then the court is going to not allow you to recast your negligence claim, or excuse me, your breach of contract claim as a negligence claim. And so it's still seen to be a breach of contract claim, whether the breach occurred because of some intentional act or due to some negligence in performing it. Professional negligence, this is a slide a little bit ago that I said that we would come to when we talked about the breach of the duties. So negligence by a professional is known as malpractice. So you've probably heard of medical malpractice. That's the term that's given to negligence by doctors, by physicians. And so that's simply what we've talked about of you have the negligence. You have to have a duty, a breach of that duty, causation, and injuries. But the standard that you're held to is different because who you owe a duty to is different as well. But the standard is that you're held not to that reasonable person, general reasonable person, but you're held to a reasonable doctor standard. Or if you're talking about in the context of a lawyer, you're held to how a reasonable lawyer would have acted under those circumstances, not how a reasonable common man or woman would have acted under those circumstances. Also, in these professional negligence cases, these malpractice cases, to whom a duty is owed is much more limited. Usually, you're limited to who the patient is or the client is. Professionals include doctors, lawyers, accountants. The doctor, the lawyer, the accountant, they're required to exercise the same degree of care that a reasonably prudent professional, another lawyer, doctor, or accountant would have exercised under the circumstances. If you fail to do that, then it's more than likely professional negligence. So now that we've talked about negligence, let's talk about strict liability. So in negligence, if you compare and contrast the two, in negligence, we've been talking about, well, how did the defendant act? Were they reasonable in how they acted? Did they do what you would have expected a reasonably prudent person to have done under the circumstances? That analysis is irrelevant in a strict liability context. So strict liability is just like you would expect. It's strictly imposes liability regardless of the defendant's actions. So liability exists without any fault, without any intent. The defendant could have done every single thing possible to avoid any injury or harm. And if they did everything that they could have, it still doesn't matter. They're going to be liable for any injuries. Strict liability applies in two contexts: products liability cases, which we talk about and analyze in the next video, and ultra hazardous activities. Ultra hazardous activities are those activities that are abnormally dangerous. So if an act is considered ultra hazardous, then there's strict liability, and the defendant's going to be responsible for any injury that occurs, regardless of how careful the defendant is. So for an activity to be ultra hazardous, the activity has to involve a risk of serious harm to persons or property that cannot be eliminated through the exercise of due care. So it's a risk that even if you take all the steps possible, you still can't eliminate that risk of harm that exists. And the second requirement is that the activity is not a matter of common usage. So it's these ultra hazardous activities are ones that don't happen on an ordinary or routine basis. So strict liability has been imposed in these 7 type cases. So one was a case in which they were storing high quantities of flammable liquids in urban areas. Another strict liability was pile driving, rock blasting, crop dusting, building a roof that allows snow to fall into the highway, locating oil wells or refineries in populated areas, and housing wild animals or domestic animals that are known to have a propensity to be violent. So these are examples in which courts have found there to be strict liability because these are ultra hazardous activities. If you're engaging in one of these activities or something else that could be classified as ultra hazardous, then there's going to be strict liability, regardless of what efforts you take to protect or warn against the harm. But strict liability has not been found to include parachuting, drunk driving, maintaining power lines, and discharging fireworks. Those are things that discharging fireworks, you can be extremely careful and protect against some of the risks of harm. Parachuting, drunk driving, I don't think those meet the requirement that they not be something that's of common usage. Same on maintaining power lines. You've got to maintain power lines. Those are something of common usage. So once the court has classified the activity as ultra hazardous, the defendant's conduct becomes irrelevant. It doesn't matter the amount of care that the defendant used. Now, it becomes irrelevant in the sense of whether or not liability is imposed. But due care, so exercising proper care, doing what you can to prevent something, can be important on helping avoid punitive damages, which we'll talk about a little bit more in just a few slides. But punitive damages may not be, or less likely to be imposed if the defendant exercised conduct of reasonable care. They took steps to avoid harm, but unfortunately, because it's an ultra hazardous activity, they were unable to avoid that harm. In those scenarios, it's less likely that a jury would impose punitive damages on you because you tried to do everything you could to protect. Respondeat superior, we talked about this when we looked at agency principles in, I believe it was week 2. We'll briefly cover this, and mainly this is just to add in the next slide that we'll go over because we didn't talk about it in week 2. But as we discussed, respondeat superior is the doctrine that imposes vicarious liability on employers for the negligent acts committed by the employer's employees in the course and scope of employment. So liability is imposed on the employer even if the employer did not know about the wrongful act, nor did the employer direct the employee's wrongful act. So they didn't have any involvement in it. Nonetheless, because it happened in the course and scope of employment, the employer is going to be liable. These are the principles that we talked about when we discussed respondeat superior in the agency session. But this is the slide that's new about respondeat superior, and I think it's a very important one to hit on because this is a growing concern. And I said this is liability for holiday parties. This is the context that it comes up in for employers nowadays, is liability for holiday parties or other parties in which alcohol is served. And so the employer will be held vicariously liable for an accident that's caused by the employee's drunk driving after an employer-sponsored event. Many courts in many states have held employers liable even though they've left. In the ordinary sense, if you had an employee who happened to kill someone in a drunk driving accident, but it's on the weekend or it's after hours away when they've been gone from their work, then there's not going to be vicarious liability. But when you hold these parties, you add in the risk of there being vicarious liability. So for these employer-sponsored events, you generally look at 3 things. Now the book puts it as 5, but a couple of them are redundant. The main things you look at are these 3. So the employee consumed alcohol at an employer-sponsored event in which the attendance was either requested or required. That puts it within the scope of your employment. So you're at an employer-sponsored event, a holiday party, you consume alcohol at the party, and you were at the party because you were requested to be there for the company Christmas party. Second, the employee became intoxicated when they knew that they would have to drive. So the employee shows up, drives there, knows the employee's going to have to drive home, but nonetheless, he still consumes the alcohol, becoming intoxicated. And then lastly, the employee caused the accident while he or she was driving home from the event, or maybe somewhere else, but they were driving from the event. If they go to the event, have alcohol, they leave, they go home for 4 hours, and they decide, well, I'm going to get up and go back out, and they go back out and they have an accident, kill somebody, you're going to have that break within it being an employer-sponsored event that they're traveling home from, and there's not going to be vicarious liability. But these holiday party liability for serving alcohol is a very significant risk and concern for employers. And in my practice, I've seen where employers will have alcohol-free parties because they want to avoid the liability that they may incur for any accidents that would happen because of an employee driving home after having consumed alcohol at an employer-sponsored party or event. Successor liability, we'll talk about this. I believe it's a little more when we look at the products liability lesson, but I know it does come back up in our material. But successor liability is just simply put where the buyer of a business may be held liable for the tortious acts that were committed by the previous owner. You could have that in if you bought a company and there was a bad design and you had product liability issues, then that could be liability that comes back for the new owner. Damages. Let's look briefly at damages. So you prove an intentional tort, you prove negligence or strict liability. What would your damages be? Well, the purpose of damages is very similar to contracts. Contracts, the intent and purpose was to put the non-breaching party back in the same spot that they would have been in if the contract had been performed. The purpose of the damages here is very similar in that it's to make the plaintiff whole. And when we say whole, we're trying to restore the plaintiff to the best that we can through the provision of money to his or her position before the conduct, the tortious conduct by the defendants, whether it's intentional tort, or it's a negligence or strict liability, whatever the conduct is by the defendant, we're trying to restore the plaintiff back to their position before they were harmed or injured by the defendant's tortious conduct. So there are a couple of forms of damages that we do this. The most common one is compensatory damages. Just like you would expect, it's meant to compensate for the injuries and harm that's incurred by the tortious conduct. This is that making you whole principle. So compensatory damages include things like the cost to repair or replace property damage. So if you've got damage to your property, you could find out what it's going to cost to repair that. So if you've had a car accident and the person was negligent in driving their vehicle and they hit you and they damage your vehicle, you know what the damage is. You know what it's going to cost the body shop to repair your car, and that would be your compensatory damages, what it's going to cost to repair your car. At times you may have a loss of market value, and that would be something that you could make up and compensate them for the loss of the value caused by your negligence. Compensatory damages also usually, and this is when we get into more physical injuries, but they include um, compensating you, repaying you for your medical expenses, lost wages from your work, and any pain and suffering that you incurred as a result of the injury. Now, some of these are harder to put some dollar value on, but lost wages, you can calculate that. If you were off 4 weeks, you know what you generally make per hour and how many hours you would normally make per week or work per week, and you can calculate what your lost wages are. Medical expenses, you're going to know what your medical expenses are because those are going to be a definite number for what was charged and paid. Now, the pain and suffering is harder to put a value on because that's not easily quantifiable. How much is the value of their pain that they had to go through and their suffering? You could have a permanent impairment as well, where you've got a permanent injury because of the conduct. Well, how do you quantify a value for permanent an injury, a permanent paralysis in your leg or whatever it may be? How do you quantify a value of that? And so that's where some of the compensatory damages are a little harder to pinpoint exactly what they'd be. But you would still nonetheless be entitled to the value to the extent it can be valued for the permanent injury that you would have. Punitive damages, we've talked about them before. I know we mentioned them when we talked about the contracts and when we talked about the constitutional principles applicable to business. But punitive damages are damages that are awarded with the purpose of punishing the defendant. And so you punish them for the wrongful conduct that they did. And it also serves as a deterrent to both the defendant, deters them from repeating that conduct, and it is meant to serve as an example to others to stop them, to deter them from committing the same wrongful conduct. So compensatory damages, it's meant to make you whole, to compensate you for this. Punitive damages are meant to serve as punishment and deterrence for similar conduct in the future being committed. Punitive damages are not automatic. There are many cases where there's negligence and punitive damages may be requested but not awarded. So they're not automatic. Punitive damages is reserved for the most egregious cases. And like we talked about, the punitive damages must not be excessive. There's some limitations on it. Supreme Court has limited them to a single-digit multiplier of compensatory damages. If they're greater than 10 times the multiple, if they're greater than 9 times, so if they're 10 times or 15 times, whatever the multiple is of compensatory damages, then it's more likely that it's going to be found that the punitive damages are excessive and violate the due process clause. So if you have compensatory damages of $100,000, but you have punitive damages of $15 million, that's going to be higher than a single digit multiplier of the compensatory damages. And so in that scenario, it's most likely that the punitive damage award would violate the due process clause. Damages, a last component of damages that may be awarded is equitable relief. Um, Even though it's a possibility, these are rare and granted in just a few cases. So equitable relief most often takes the form of an injunction. An injunction is an order by the court to either stop conduct or it's an order to take certain action. So an example is, you talk about nuisance as an intentional tort. If you have a nuisance, and I think the example we used was where I had done some some improvements to the drainage of my property, and it was causing water to flow across my property and flood my neighbor's uh, backyard. In that case, the court is likely to grant an injunction compelling me to stop the flow of water as it is so that it would abate, it would take care of, stop the nuisance that's occurring. So I would be ordered to change the natural flow of my property back so that it does not cause my neighbor's backyard to flood. That would be an example of when an injunction may be granted. So the last thing under damages to talk about is how do you treat when you have multiple defendants? If damages are awarded and there are multiple defendants, how do you decide how the damages are allocated among those defendants? Well, there's a doctrine known as joint and several liability, and this means that the defendants are jointly liable, they're all collectively liable, and they're also severally liable. So under it, the plaintiff may seek recovery from any defendant. They may seek it as a combination from, if there's 3 defendants, they may seek a third from every defendant. But you also may have 2 defendants who have no money and 1 defendant who has deep pockets. You may have a business and 2 employees. And if you have the 2 employees or hourly earners, they're not going to be having the financial resources like the company will. In that scenario, under the joint and several liability, the plaintiff is entitled to go after the business to recover any judgment that he's been awarded. Now, joint and several liability has been limited in most states. The contribution and indemnification doctrines are the reaction to help alleviate the harshness of the joint and several liability rule. And so contribution allocates the loss by requiring the defendant to pay his or her proportionate share. So we talked about an example, or we talked about, not an example, but the doctrine of comparative fault. If you have a bunch of parties involved and there's multiple defendants and you have fault allocated among the 2 defendants, and one defendant is 40% at fault and the other one is 60% at fault, well, under the contribution rules, the 40% person is going to be liable for 40% of the award, and the defendant allocated 60% fault is going to be responsible for 60%. And the indemnification, if you don't have some allocation like that on the comparative fault principles, if you go back to what we're talking about, where you may have joint and several liability, where you have one defendant that has deep pockets and 2 that don't, and they go after and get all their money from the business, then the defendant business under the indemnification rule has the ability to go after and have the court order the other 2 defendants to reimburse that business for the portion that they owed of the settlement. So it helps lighten some of the effects, if you will, of the joint and several liability. But like we're saying, contribution and indemnification are really only helpful if you have defendants who have financial resources or assets. So if you only have, if the 2 individuals can't pay anything, they can't. You may try to have them ordered to reimburse you, but if they don't have the money, they're not going to be able to. So contribution and indemnification principles have their limits, and they're kind of stifled when you have defendants involved that can't pay their proportionate share, that you have where the defendant that has those resources may be left holding the bag, so to speak, and covering the damage award that financially solvent company is going to suffer because they have insolvent co-defendants.